Hello, everybody. Welcome to another episode of the Justice Revolution. Happy Friday to everybody. It was a little weird. We did a broadcast on Monday this week, so it kind of felt a little odd. But we had more viewers. Maybe we should start doing that. I don't know. I am your host, James Patriot. I have my co-host with me here, Erica from Indiana. Say hello, Erica.
Hey there.
Got my other co-host, Justice, from just down south of me and up in the mountains. Say hello, Justice.
Hi, everyone.
Guys, I have with me a good friend of mine and our special guest today. We got Brandon, the Big Sib, with us. Some of you guys know he has a Telegram channel. It's the Big Sib Law, right, Brandon? Is that right?
Mm-hmm. Yep.
Yeah. He's got a YouTube channel that's been doing really well for I don't know how long. He and Alphonse were recently on an episode and fill us in on that episode. I was listening to it the other day. It was really, really interesting. You were talking more about the difference between, statutory construction of, what a person is according to the law and so on and so forth. So give us a brief background.
Well, I guess over time, James, we have different viewpoints of the word person. Well, we know it's a term of art, right? So the back and forth, both one side saying person, people would say that the person does include the natural man, and the other side says it never does. But the truth is that it's smack in the middle. It's on subject matter, content, and a couple rules of interpretation, right?
Mm-hmm.
Like for instance, the word people or personal always include the sovereign. They're not terms of art, right?
Yeah.
That's
pretty cut and dry.
Terms, can I interrupt? Terms of what are you saying?
Art.
A-R-T.
A-R-T, terms of art. Terms of art. So what I did was, like I usually do, I go out to try to prove a thing, and I ended up, I was at the point in time reading one of Antoine Scalia's books, Making Your Case. And during that, I took a drive on the road, decided to listen to a YouTube video of, I think it was the Hoover Institute, and it had Justice Scalia on it. And he started talking about one of his books called Reading the Law, Matter of Interpretation, the 47 Canonical Rules of Statutory Interpretation. So I bought it. And lo and behold, about a month later, I started understanding things. It comes in stages, the revelations as you learn legal language, right? And so the synchronicity of it was time for me to have this book. So I started reading it. And the rules of interpretation include things like the word person doesn't always include the sovereign, right? That's a rule of interpretation. Justum generis, which is things of like kind, associated words, which is noscitur a socius, right? In Latin, is that associated words follow their meanings by context. So the simplicity of the IRS statutes, just for example, Title 26, Article 7701 lists person as an individual, corporation, joint stock company, a business, public or private association, and partnerships, right? Well, each of the ideas after individual has a contextual definition. So they are going to decide the definition of the preceding one. It's period. So it can include the sovereign. It just can't do it by statutory interpretation. But these 47 rules of canonical construction, so I'm reading them, and I've read the book twice already, and now I have a new perception of how to actually read statutes. And it's funny because Scalia even says that 90% of the lawyers coming out of law school don't know these rules anymore. So we're in a situation where the Supreme Court and the appellate courts are ruling correctly, that the EPA, CDC, FDA, CMS, and all these agencies who have been able to interpret their own statutes since the Chevron deference of 1984 are all of a sudden saying, no more. Matter of fact, you're broadening your statutory authority too far. And you read these cases and you don't understand why they're ruling this way. For instance, just one little word is what the CDC brought up, was the word sanitation. Well, the plain ordinary language meaning had one, and then the associated word text with sanitation. Sanitation never included people. It was the power to clean things, right? So this is why their CDC mask mandate fell, and all these court cases are ruling correctly. So we've got good people at the appellate levels, we got good people at the Supreme Court levels, and what we're seeing at the trial court level is what I would call judicial activists, right? Who probably don't. Not all the trial court levels, especially here in Baton Rouge, can read a statute properly. The magistrate's rulings, it reads like somebody out of Bethune Cookman Law School or something like that. I don't know. It's the worst writing that I've ever seen. But anyway, that's what it is. These 47 rules of interpretation are important for moving forward, and it's really opened up another pathway for me to see correctly.
Awesome. Yeah, and it's a great episode. I suggest you guys reach out to it. What's your YouTube channel, Brandon?
The Big Sib. No, that's it. The Big Sib YouTube channel. You'll know it's me because I've got the Tree of Life as the avatar.
Awesome. Awesome. And just so everyone's clear, that is the Big Sib with a B, not with an N. I apologize. Yeah, we had a typo. I mean, the B and the N are right next to each other on the. So it's really hard, when you got your fat fingers and you're trying to. We had a good laugh about that. So, anyway, well, thanks, Brandon, for being here. I appreciate this. We've been doing the last few episodes. We've been talking about jurisdiction, specifically how these kangaroo courts, as we come to affectionately call them, how they think they have jurisdiction and when in reality they don't. And then we're teaching people how to challenge that. So if they're currently in a situation or they're being threatened with it being in a situation where they're going to have to challenge jurisdiction, a lot of people aren't sure how to do that. So I have a friend of mine who lives south of me in Justice, down southern Utah. We've been helping her. She's been kind enough to allow us to use her case as a reference point because it's a really good one. So I'll just give everybody a brief update of where we are with that, and maybe Brandon, I could probably show you what we came up with to get your thoughts on it. But long story short, she was in a very abusive relationship last year. And there was a situation where she and her ex-boyfriend were arguing, and somebody saw this and was concerned, and so they called the police. By the time the police arrived, she had already left the scene, so it was just the ex-boyfriend was just there. So then the police start to question him and get some information. Then they question the individual that called the police to begin with. Then they find that and I'm taking this information from the affidavit of probable cause that the officer submitted. He says they notice her vehicle driving by, so they make contact with her and get her side of the story. And then they find out that apparently they were spitting on each other. There was a whole bunch of different things. The funniest line is, and you'll see this here, Brandon, in a minute, is in the affidavit of probable cause, it states that she apparently took the contents of a glass bottle and dumped it on his car and then licked the door. So I think he meant to say kick the door, but the K and the L are right next to each other on the keyboard here. So maybe that was another typo situations there. Anyway, so what ended up happening was the officer who responded says in his affidavit of probable cause that he reviewed video footage from some store that was nearby. It's like a check cashing store. And it says it appears to show her doing these things. And so then he arrests her. And he takes her to jail. She's released from jail on conditions. These are both, she was charged with a domestic violence assault, and she was charged with disorderly conduct, both of which are Class B and a Class C misdemeanor, I think, here in Utah. So they take her to jail. The magistrate reviews the information, gives her allows for a release, and one of the documents that they told her she's required to sign was an agreement that she wouldn't have any contact with the victim. However, nothing in the affidavit of probable cause states who the actual victim is. There's no affidavit from the victim in the court file. And not only that, the protective order that she's required to sign, it was almost in passing where she was walking out the door and said, "Oh, well, you have to sign this thing too." So then, I mean, I'm going off on it. This is really going to make your head spin, people. But the struggle with this is that protective order, whatever it may be, is not in the court file. It's not part of the court docket. It's not there. I've looked, I've double checked, I've triple checked. It's not there. So there is nothing on the record to state that she actually signed one. Well, she's released from jail. Then the police, and I'm reading the affidavit of probable cause for the next situation, because when she's released from jail, there's an officer who, I don't know, I don't know if he had nothing else better to do or what the situation was, but he's notified that she's released. And so he's essentially following her. And her vehicle, from my understanding, was back at the original scene, and her ex-boyfriend was there. So she went to go back to get her vehicle. This other police officer sees this, and he steps in, and we'll read the affidavit of probable cause in that case. Well, she's arrested again, this time arrested for violating a protective order, and then the cop throws on a trumped-up charge of assault to a police officer and resisting arrest. So now we have quote-unquote felony charges. Well, actually, they're technically Class A misdemeanors, but for all intents and purposes, it's a felony charge. Does that make sense so far? Have I lost anybody?
No, you've got me. I just now I understand why you enjoyed me sharing that Clark decision, because you were working on this. Yeah. Yep. So now it makes sense to me why that posting of that case law. But again, even the affidavit of probable cause is an assumption by the police to believe one or the other without firsthand testimony. So, I mean, again, how these things work just blow my mind.
Well, we go through and we tear this thing apart. I mean, the affidavit of probable cause is, well, it's garbage. I mean, because it's all based on secondhand testimony. And there's no firsthand accountants of anything. So the officer didn't actually see any of this stuff happening, which, is infuriating. So let me open up and pull that out here. So I'm going to show you, Brandon, the document. I wrote up a motion to dismiss. Well, before I get into the motion to dismiss, let me tell you what's happened now. So, can you tell me the Utah code she was charged out of? I've got the misdemeanor code pulled up. Yep, it was 76-5-1022. I've actually got it written out right here too, but you can look that up while I'm talking. So yeah, I'm just checking stuff out. That way I can speak intelligently. Yeah, no problem. So 76-5102, right? Yep, 102, and then it's subsection 2. 76-5-1022. So it's under assault and related offenses. Gotcha. I'm there. Go ahead. All right. So, well, is that right? No, because it's supposed to be the. I think I gave you the wrong one. I think it's supposed to be the domestic violence one. Let me. Okay. I got a bunch of different tabs open on my screen. Let me make sure I have that right. Yeah, because this is assault. Yeah. That's actually what I I copied that word for word from their affidavit of probable cause. Let me just double check and make sure that's correct. I want to make sure I have that. Where is it? Yeah, 76-5-1022. So. However, that's because when I pull up 76-5-1022, that's not what I get.
Oh,
An actor commits assault if the actor attempts with unlawful force or violence to inflict bodily injury on an individual, or B, commits an act with unlawful force or violence that causes. So you have to have bodily injury for this particular one. You'd have to have both, either or. You'd have to have, because it's or. You got the or, so you have to have one, either A, B, or 1 and 2. And you have to have, each one of them has to have bodily injury. So which one was hurt?
That's just it. There's nothing that states that. So,
okay.
Yeah, that is odd. I didn't, and shame on me for not checking that, because I just, again, this is why we check things, right? Because these prosecutors are dumb, and they're just copying and pasting.
While we're here too, if you can show the screen, I'd like to teach people the and/or conjunction too.
Yeah. Do you want do you need the capabilities to be able to share your screen?
Well, yeah, here I can do it. Let's learn something together. Share screen. I've got it. To share. Okay, so I don't know. There we go. Yep. All right, so guys, let's do this, because this is a huge deal. When interpreting statutes, finding the elements that must be proven. So you've got A and B. Okay. An actor commits assault if the actor, A, attempts with unlawful force or violence to inflict bodily injury on an individual. When you see the or, okay, it separates the clause.
Yeah.
And what that means is you have to have either A or B. Okay. A or B. If the word and was there, you would need A and B.
Yep.
That's right. That's right, James. And so you go or commits an act with unlawful force or violence that, and it goes to 1 and 2, causes bodily injury to an individual or creates a substantial risk. So the subjective substantial risk would be like running at somebody with a hammer, swinging and missing, right? So that would be a substantial risk. Two people spitting on each other is not a substantial risk of bodily injury. Neither is either of the victims here, because it's a domestic dispute or whatever, are going to have if neither one of them displays physical signs, neither one of them should be charged. And matter of fact, it's a malicious prosecution by and frivolous. So if this is the actual statute that they're being charged with, this lady's being charged with, it's completely bogus.
Well, can I interrupt?
Yeah, go ahead.
She's with us in the chat, and she posted that she was hurt. So one of the two was hurt.
She was the one
being charged?
Yes.
Yes. So from my understanding, they charged them both.
Okay.
They charged her and they charged him.
Okay.
But what's in her case, so this is what boggles my mind, is like, okay, so here, let me pull up the affidavit of probable cause for this case, for the precipitating case, because that's what's going to really, let's see right here. Yeah, because this is just going to make your head spin, and you're going to be like, wait a second, this doesn't make any sense whatsoever. Right, Erica?
It just does me laughing just thinking about it. It's that ridiculous.
Yeah. So here it is right here. All right. So this is from his name, Officer Thompson. He's the police officer that wrote this. And this is the statute that she's being charged under. He said that the defendant was arrested for this offense. Okay. Oh, never mind. Okay. Heather's in the chat. She says they did not charge him. Okay.
Okay.
Oh my gosh, this is just asinine. Anyway, so what you see here is when you read through this, it says the officer, I'm just going to jump down to this spot. Whoops, right here where my cursor is. While speaking to Matthew, Heather drove past the scene and contact was made with her. It was discovered she was upset with him because she got pulled over. He didn't stop. They were in separate vehicles. It says that she found him parked at this check cashing place and confronted him. Matthew spit at her, and this upset her even more. She tried to spit on him, but was unable to. She went to her car, grabbed a glass bottle, and tried to dump the liquid contents onto him. She threw the bottle at him. Heather hit Matthew's windshield and kicked the door. Heather again approached Matthew and started to hit him. Heather then got into her car and left the area. So he says he made contact with the witness, who became alarmed and called the police. The witness stated she appeared to be the primary aggressor. Witness stated the female hit the windshield with the bottle and licked the door. There's that licked. Witness stated he was unsure if female tried to hit the male with the bottle or if she threw it at him, but it ended up on the ground. Video surveillance was obtained where it shows Heather hitting the vehicle and appears to hit Matthew. Heater was then arrested. Not Heather, but Heater was arrested for domestic violence assault, DV assault. So that's the probable cause statement that this guy was talking about.
So where's the bodily harm? I mean, he states it right there. There's another term of art in there, right?
Mm-hmm.
Appearance of doesn't mean it actually happened. Heather appears to hit. But if there's video surveillance, either she did or she didn't. It's the law of non-contradiction. Either it happened or it didn't. And, well, I mean, we were talking about objective reality. Either the overt act happened or it didn't.
Yeah. There's no gray area here, and that's what I noticed too. And we noticed that last week when we went over this, right, guys? Is, well, for one, everything this officer stating is third-party testimony. This is all based on hearsay.
His affidavit is hearsay.
His entire affidavit is hearsay.
Well, just about every single one coming from cops are contained, unless they. And this is the exact reason why the Idaho Supreme Court made the Clark decision. Right?
Yes, they did.
Because of this type of stuff, he said, she said stuff is completely going to rely on somebody else's perception, right? This cop comes up, maybe he's been in a domestic dispute before. He's got his own perception of it. Now this has become part of the case, and really it never should have been. And of course, domestic disputes are an issue already, especially two people in the throes of passion, walking that line of love and hate. Things get said.
Yeah. Well, and Nachi Velasco, you're absolutely correct. They're trained to follow administrative rules. They're not trained to follow the law as it's written. And you'll see why that is the case. Well, so when I talked with Heather, I said, okay, send me everything from the court. I need to see the certified court record. So she sent me everything for both of these cases. Remember, I told you there's this case that precipitated. The second case was this alleged protective order was issued that she was supposedly violated. So she sends over to me last night the discovery file that her public defender got, and the only photos in there of any injuries are actually photos of Heather herself. So there's no photos of the victim or the alleged victim. So that's a problem. The other thing too is, according to the affidavit of probable cause, the officer determined, and he made the determination to arrest her based off of the video surveillance footage. Well, where is that video surveillance footage? Is that not supposed to be part of that discovery package?
Well, yeah. If it's used as evidence, it must be in evidence.
Exactly. Well, it's not there.
Huh?
It's not there.
Well, if you can't cross-examine and examine it and view it for yourself to defend yourself, then what do we have here?
Well,
we have an inability to defend yourself.
Exactly. Let me show you.
And who is her accuser?
Exactly. There's no, again, it'll just make your head spin. So, but if it weren't, oh, whoops, that's the wrong one. If it weren't so, if this didn't just happen so frequently all across this country, and that's the problem, is this happens everywhere. So, let's see.
And this seems like, and for Heather and people, most people aren't having issues at the higher echelons or doing federal court cases. This is a great segue into why it is important to, one, be able to read law, understand law, and then walk into a courtroom and go, you're missing elements here. You have to have these essential elements to get a conviction. And so it's kind of, people have to understand this. For so long, there's always risk versus reward. And what do I mean by that? The reward for these local government, state governments, and federal government has been so high,
Yep.
and the risk so low for so long that they've been able to just be revenue agents. Okay, you're starting to see that pendulum swing back, right, where it's becoming too risky for them to not know the law anymore and just be revenue agents. And it's going to be on little stuff like this, right? This lady goes in here and gets a malicious prosecution and gets these charges dropped. Guess what she can do? She can turn around and sue the city. And it's going to be important, because then you have a civil case. You got malicious prosecution here. And guess what they're going to start doing? They'll do just like Idaho, who finally had to pay enough money out for getting involved in people's private affairs, and say, hey, we're not getting involved in it anymore.
Yeah. We're going to do this the right way. We're going to take their statements. We're going to build an investigation. We're going to take this information to a judge and get a warrant.
That's right.
We're not just going to arrest them based off of that information. Well, you'll see how I attack this here. So again, based on this information, I know this has been a bit of a going through this again. I wanted to go through this again because it's important to understand where this goes from here, and why this is important for everyone to know. Just exactly what Brandon said. You have to know how the law is written. You have to know what or and means. And if there's an essential element, it must be present. So in our motion to dismiss, first of all, the charging documents, the information states the city of St. George, right? That's the plaintiff. So, I made this joke with Heather last week. Apparently she must be Superwoman, and that whatever she did, she caused damage to the entire city of St. George, allegedly. So when you see this right here, when you see city of, county of, or state of, and it doesn't matter if it's in all caps or not, that's irrelevant. When you see it start with the city of or state of, they are prosecuting you administratively. You know that. Because if this were truly a criminal court and one where she was being tried in an Article 3 court, this would say the people of Utah or the people of whatever state. The people
James,
versus so-and-so. Yes.
What is the difference between the administrative and the other court, and why should someone be concerned?
Well, geez. Brandon, do you want to take that one, or do you want me to?
In a nutshell, there's lots of new people coming into this movement.
Right. That's a good question, because that's one I found myself asking almost right away, because everyone kept talking about Article 1 courts and Article 3 courts as if I knew what that meant.
Yes.
Well, it's just, let's simplify it, right? To administrate something is to execute it. So it's running out of the executive branch. Okay. So you're not going to have all the rights of due process. So when you step into an administrative court and you go, I've got rights, right? Well, yeah, you do, but they're not here because the court lacks subject matter jurisdiction to even hear those. So that's one thing out the way. And now you're in what's called code pleading. Louisiana allows fact pleading. I'm not sure about Utah, but you're in statute and code pleading, right? And so within that little framework, and most of us believe outside of the law and inside the law, that when you go into a courtroom, that due process works, and we have a certain idea about it, but it's not the way it's running off the administrative rules, just like federal agencies do or state agencies. It's an executive branch. It's not you can't go in there and plead your state constitutional rights. Court can't hear it.
Well, that was an interesting graphic there, James.
You like that?
It looked like you were walking off into a tunnel.
So
when a situation like this happens, and we know administrative, is also a cash cow.
Yep.
So when something like this happens, her best recourse is to sue them, right?
Well, yes and no.
In an Article 3 court? Okay.
Yeah, I mean, we're going to get there. We're going to bring them into an Article 3 court, whether they want to be there or not.
Okay. I just want the viewers to understand, if they find themselves in this situation, what their recourse is. And
yes, well,
how would you know what they're pulling the wool over your eyes?
Well, so the first thing that everybody needs to do is first get the simple things down, right? It is much easier to get to sue after you've had the charges dropped. It's not saying that it is an absolute bar, right? It's not an absolute bar to go to an Article 3 court. It's just much easier once you defeat in this lower level court to turn around and then go into a civil matter where the rules of civil procedure actually apply. Especially even in your local courts, most people, they're not even operating by the state rules of criminal procedure or the state rules of civil procedure. They're running out of statute. They're running out of statute, and every state's got it. And I adjure everybody out there to go read your state's Administrative Procedure Act. My state started in 1964, and all the agencies that are operating out of that Administrative Procedure Act are limited by statute. But guess what they've done? They've broadened over the last 60 years to incorporate everybody and everything because it is they are revenue agents.
You guys search any one of your cities, counties, townships, villages, wherever it is you live. Just go out and do on a quick search on the website Dun and Bradstreet. Type in the name and see how much money they bring in each year. It'll make you sick. And it talks about they have sales in excess of such and such. It's like, well, what in the crap is this city selling? Because I'm not buying anything from them. They're not. They have taken every single one of us as the sovereign men and women that we are, and has made us believe that we are creatures of the state. Oh, you have rights. Oh, yeah, you have a right to an attorney. You have a right to a trial. You have a right to this stuff. Like they pulled it, but they don't tell you that that's a let's call it a simulation of a legal process, because that's what it is. It really is one, but it is completely devoid of everything that court needs. And Brandon hit the nail on the head. He said the minute you walk into that court lacks subject matter jurisdiction to hear anything about we the people. So, Justice, you brought up the question, well, what do people do? Well, the first thing you're going to do is you're going to file a motion to dismiss.
Right.
You're going to point out the deficiencies. You're going to talk about how the court does not have subject matter jurisdiction, and you're going to claim, again, if I'm making this claim, right, when I say here, Heather McGuigan, the alleged defendant and one of the sovereign people of Utah, who's going to come in and tell me or tell her that she's not one of the sovereign people of Utah?
Yeah.
Who and what evidence do you have?
What you do simply, and especially in little things like this, okay, little things like this where the prosecutor is so used to everybody walking into that courtroom and going, I'll plead out and I'll take the 20 hours of community service. They want it. Okay. What you have to become is that guy that the prosecutor, after the first, second, and third encounter, goes, all right, this isn't worth it. The risk is too much because we do not have a case, you know? And that's what you're going to find out. They're not used to people walking in there and doing, because most people are programmed to believe when they walk in that courtroom, they're already afraid anyway. And it's from a lack of knowledge in the first place, because when you walk in and you have knowledge, guess what? All the veil falls away. But this is the first stage in bringing it back, because again, it's simplified.
Okay.
They haven't had enough risk and they've got too much reward.
Yeah, and that's it, and it's like we've been talking about. You know, it's this has been our mission, right? Justice from the very beginning is to educate as many people as possible, because I'm only one man, Brandon's only one man, Erica's only one woman, and Justice is only one woman. There's only four of us. So
are you sure about that, James?
Well, I don't know. These days you could be 15 women. Who knows? But or you could be 15 furries. I don't even know what that is.
So I have one more question before you.
All right, go ahead.
What does this administrative court have jurisdiction over, or is that too long of an answer? So could we provide a list for people on Telegram of what an administrative court has jurisdiction over and what
basically the simplest answer is this: the administrative court only has jurisdiction over public servants.
So the cop.
Correct. So let me put it to you this way. Let's say I'm working for the Parks and Recs department, and I go out and I beat the crap out of another employee. They can prosecute me in an administrative court, and it would be binding. Because, well, I work for the city. I'm a city employee. It's no different than if this up here was to say the corporation of Walmart or McDonald's or name any other business. It's no different. So the way that this and you guys, you got to take your hat off to these people. I mean, they are evil geniuses that came up with this plan.
Mm-hmm.
You know, go back to the 1875, 1876, when they formed the Bar Association. These guys knew what they were doing. They're like, hey, we can make a buttload of money. We can do it under the color of law, and we can make it look as though this is legit.
Yep.
Because the people don't know any better.
Evil is the absolute word.
We'll just read a couple definitions from the Louisiana Administrative Procedure Act, okay, to Section 950.
Okay.
And just for people to get this. Number 2 is agency, means each state board that goes on down through Article 6, 44. Party means each person or agency named or admitted as a party or properly seeking and entitled as of a right to be admitted as a party. Number 5, person means any individual, partnership, corporation, association, governmental subdivision, or public or private organization of any character other than an agency, except that an agency is a person for the purpose of appealing an administrative ruling. Rule means each agency statement. Then you just keep on going down. Rule making. This is administrative procedures. So each the state, when you go and get a license and the Secretary of State signs it and grants you the ability to get involved in intrastate and interstate commerce, you are now bound by the rules of the administration. In that, that's what it is. Okay.
Are you talking about any business or as a?
Yeah. Well, see, he who creates controls.
Yep.
Although you ask the state for your LLC or whatever, when they sign it into existence, the state created it, right? Yep.
You're operated under their laws. Yes, you're created under their laws. Yes,
you're created under their laws. That's why you got to go hang your little certificate of authentication or whatever else it is, right? So when they come up with this, and so people can just understand this. This is regulatory schemes. So in order for the regulatory scheme to work and for the administrative side of law to push into every facet of life, you'll see that the time they started coming out with this was also about the 50s and 60s when education took a nosedive.
Yep.
Right. So it's a direct correlation, right?
Yeah.
You can see it. Now people can't even read and write. Well, guess what? If you can't read and write, there's an 18th Scottish poet who stated that if you want to enlighten yourself, learn the English language, and it's one of the greatest detriments to reading law, interpreting law, and then even reading things simple as your Bible, because there's rules of grammar throughout that even only people the highest English professors in the United States right now don't know a simple rule such as the gender neutral rule. And it's crazy to me because it's been part of our jurisprudence for 500 years that when you see the word man, the pronoun man, it includes what?
Woman.
It includes woman. Always has.
Yep.
It always has. This is a rule of interpretation. When you see woman, it includes what?
Man.
These simple
both ways.
So why is these English professors out here talking about non-binary pronouns? Because they don't know. Even higher learning has lost it. So you don't even. Yeah. But anyway, that's a tangent to get off on. But again, go read your Administrative Procedure Act.
Yep.
You'll find that your local court rules are running out of statute. That's why it even say like your city rules, right? You have to go to the city's website or to the courthouse and ask for their rules. And you'll see they don't include constitutional provisions.
Yeah, it's disgusting, and to Brandon's point, he says, about 1950s, 1960s when education took a nosedive in this country. I was reading something about, gosh, why can I never remember the guy's name? The Frenchman who came here, Brandon, help me out. It was like in the 1830s.
Alexis de Tocqueville.
Yes.
Yeah.
He said in his memoir, it was like 1830, 1840, right? And he was just spent 4 or 5 months walking around here, talking with Americans. And he said it was hard pressed to find anyone off the street who didn't know the Constitution and didn't know the rights that were protected by it. Mm-hmm. Nowadays, you can't find anybody. I was having a discussion earlier today with someone who said that there's somebody who's up for a federal judgeship who doesn't even know what the 5th freaking amendment is.
Well, no. Yeah, that's right. And Senator Kennedy asked her yesterday what was the definition of what is called purposivism, right? Mm-hmm.
He's great.
And if you don't know what purposivism is, you need to go look it up. This is where judicial activism comes from, and this is the side where whatever I believe these letters mean. And so you have two different ideas. The scriptures, when we read the Bible, we're talking about the spirit behind the letter, right? We're talking about this. When you're reading objective law, what is it supposed to be? The letter.
It's not the spirit. It's what does it say? Exactly. Yeah,
that's right. That's why.
Hence the letter of the law, right?
Yep. That's the letter of the law. Two different deals. You read the two differently.
Yeah.
But so what we've come to now is what is called purposivism, where we're gonna pontificate on what we think the legislator's intent was, because we can actually know that. It's a logical fallacy in the first place, right? And this is how we see where equity is being turned upside down. Equity is a good thing, but without law, it's baseless. Exactly. And equity now is being pushed to say, well, equal rights, privileges, and immunities to all. Well, that means this man can't be discriminated going into public accommodation because he calls himself a woman, right? It's okay for that. That's equity. And that's why you'll see the talk all the time. And whenever you hear somebody say diversity, inclusion, and equity, know that this is a judicial activist. This is somebody that's mind is completely warped.
Yep.
Well, the people that are pushing that certainly don't want to give up their mansions and their bank accounts to be equal with us. They want us to be equally serfs for them.
Yeah. Well, and so this is a great discussion too, because it gets back into how did something like COVID-19 exist in the first place? Because intellectuals somewhere, some third party, thought they knew enough about us, everybody out here, that they knew, without taking any liability for it, without firsthand personal knowledge, that we needed this medicine. We needed these masks, and they were going to guide us to it. And Obama had a great speech, not a great speech, but a speech where he said, fundamentally, we're going to change America, right? And then he goes on and he talks about how we've got to take from the American people the ability for them to continue hurting themselves. Whoa. They have this utopian dream so they have this false utopia that with the right systems of government and the right social system in place, the world's going to be a utopia. That's false. It's never going to happen. Never has happened. Never will happen. Never going to happen, because man is infallible. You have to accept that.
I'm going to post the Communist Manifesto in the Telegram chat, because it will help a lot of people relax a little bit, because people are caught so off guard, not realizing this is a repeat pattern. And
over and over.
If you read the Communist Manifesto, then you can fight them. You understand what they're doing. You understand the gaslighting, the mental disruption. All of this stuff is on purpose to wear you down. But anyway, not to go off. Yeah. We got a quick question here, and then let's move on. But I'm going to post that for you guys. I highly recommend reading it.
Yeah.
Just one quick thing when people read that, I want each and every one of you out there to go look up what a logical fallacy is, and like a zero-sum fallacy. You'll hear this, right? So there's zero-sum fallacies, game theory fallacies, the either-or fallacy. All these fallacies, go look at them and then read the Communist Manifesto and see how many fallacies you have in there, okay? You will see it over and over again. Learn how to think instead of being taught what to think.
Got to beat them at their own game. But this is a question I'm curious about.
So if I'm understanding, and by the way, Unmasked Science, this is Heather, and I really appreciate her jumping in here and allowing us to use her case as a use case, because it's going to help a lot of other people. So her question is it that administrative court has different definition of words than an Article 3 court? Not necessarily, Heather. It's that they're moving. Think of it this way. The administrative procedure or the administrative court has one set of procedures. The Article 3 court or the the constitutional court has another set of procedures. Those sets of procedures are much more time consuming. There's a lot more work involved. There's more things that have to be done to be in that situation. And so it's not a profitable place to be in. Whereas the administrative court and the procedures it has outlined, man, they can just go like clockwork. I mean, how many times have you guys been in traffic court? There's 15, 20, sometimes 30 people standing in there. They all go, oh, guilty, not guilty, whatever. I'll pay the fine. And they go. This is a business. As sad as this is.
It's a rule of thumb, too, for everybody out there. If you're reading the statute, always go to the definition section. Every definition section within each statute is going to define specific words. Okay. Yep. Those words can't change. They can't broaden those words. Those are specific. So when general words are used, they're going to fit the specific words. Yeah. That's just a rule of thumb.
Yeah, it's a rule of thumb. So, for example, up on my screen here, this is the motion to dismiss we have. So under the Utah Code, Title 76, this is the criminal code. So when you look at Title 76 under the definitions, you're going to find person, and person is defined as an individual, comma, a corporation, comma, an association, comma, all these other things. So Brandon, what does that mean? Yeah, you got here.
Well, let's read the whole thing to them. I'll switch to my book. I just so happen to have it here. Just
I'll put it up on the screen while you're looking it up in your book.
Okay, go ahead. It's the Associated Words Canon 195. Let's go to it.
So the biggest difference thus far is the jurisdiction. They have no jurisdiction over her in a case like this, but they are attempting to, and they would unless we knew better and try to get it dismissed based on those reasons, correct?
Well, so let's go back here. And if it was following the criminal procedure, right, like actual criminal procedure, she had the right to a speedy trial. She had a right to a jury by trial and all these ideas. If you pay attention, when you go into these courts and you start signing the papers and you read the small line, they're asking you to waive all that. There's a reason they're doing that because by the Constitution in state and federal, when a criminal case is brought to you, guess what you get to do? Cross-examine, depose. You've got the rules of a discovery to use, and guess what they don't want you using in these administrative courts?
They definitely don't want that stuff getting out.
That's right. So,
all right. So did you find that, Brandon?
Yeah, I've got it. Associated words bear on one another's meaning. This is associated words canon. And for anybody out there who wants the book, I'll shove it up here. It's called Reading Law by Scalia and Brian A. Gardner. It is the rules of statutory interpretation. Okay, the Latin phrase "noscitur e socius" means it is known by its associates. A classical version applied to textual explanation of the observed phenomenon that birds of a feather flock together.
Mm-hmm.
The associated words canon can refer to the basic principle that words are given meaning by their context, and some authorities use this canon at the broad level of generality. And so you can go through here and you can find little deals, but you have to know these canons and why. So when you wield the word with concise and precise pinpoint paper arrows, your enemies cannot come against you because you're wielding what is called the two-edged sword, the word of God, right? And your face shines as the countenance of the sun. Because you're acting in truth, honor, and integrity, and they cannot defeat it. They can't in any way, shape, or fashion. If you're in the right and you do it right, you're going to win. Yep. Eventually, you got to get to an adult, though. Just make no mistake about this. We are at the pinnacle of the pendulum swing in the age of decadence. You can see it starting its drift back.
Yeah. Yeah. And it sometimes it takes a while and multiple different courts to get to that adult, but we will get to an adult who actually has a head on their shoulders. So, Erica, I have up on the screen here, this is the definitions according to the Utah State Legislature for the criminal code. You want to read what person means? Can you see that?
Yeah, person means an individual, public, or private corporation, government, partnership, or unincorporated association.
Okay, perfect. So, going off of what Brandon just told us, reading that definition, what does that mean? Does that mean does that mean me or you as one of the sovereign men or women? Or does it mean something else?
I'd say no.
You'd say no. So you say
else.
no, it means something else.
Yeah.
Well, you'd be correct. It means something else. So,
and let me show you the difference. I'm going to show y'all the difference in Louisiana's civil code, and it's a beautiful thing. I'm just going to show it to you because this is pretty cool. There's no mistake. There's no ambiguity here. All right. Let's see. Did I show it? No. Stop sharing.
Oh,
okay.
I just added it and then you hit stop.
Okay, I'm sorry. Here we go. All right, now do it.
There you go.
Okay, so let's go. This is Louisiana criminal code. Now watch what the person means in Louisiana. Includes a human being from the moment of fertilization and implantation, and also includes a body of persons, whether incorporated or not.
Louisiana's a different animal altogether.
Oh, man.
So yeah.
Wow.
Hey, look, people don't know, and I didn't know either until I really started going through the Louisiana Civil Code. You want to know why so much law stuff happens in Louisiana? Because of the merchant laws, and they were so explicit. Yeah. So some of the lawyers here are some of the best in the world. They're corrupt as all get out.
Yeah.
But you can see right here that this was completely thought through. Right. There was no ambiguity.
A human being. They wanted to say everything they possibly could say without saying man or woman or one of the people.
Yeah. But you know what? You can't go in here. I can't argue this. Yeah, there's no room for me to wiggle because this does not have what is called the canon is called person doesn't always include the sovereign.
Correct.
Well, this person definition does include the sovereign.
Yeah.
And of course, go to another one includes means it excludes another, right? So exclusio exclusio. So the second inclusion here, right, could very well exclude this first one.
Yeah.
That's it.
Then this begs the question then, because I ran into an old friend from high school who's a big time police officer now when I was picking up some sushi the other day. And I asked him what he understood about a sovereign. And he rolls his eyes and he's like, oh, those sovereign citizen people. Right? Like there's the only knowledge that they have of a sovereign, which we all are, like there's a presumption has been made otherwise that we're a part of their corporation. They have authority over us. But then it always comes back to what responsibility does the sovereign have, if any, to establish their sovereignty? To avoid stuff like this. And if you do, does it help anyway? They'll still just roll their eyes at you and be like, oh, that crazy nut job.
Well, and so the word sovereign, one of the best quotes you'll ever see about sovereign. Sovereignty isn't given to anyone. It must be obtained. And what do I mean by that? We're all born into limited darkness, means we're ignorant from birth. Okay. The man must grow, or woman must grow into a knowledgeable being, fully aware of his responsibility to everyone around him. So if the word sovereign means full dominion and also full awareness of how to act, how with logic, reason, and then that's how to think. And then we add morality, which is the overt act. You know how to act towards your man or woman next to you.
Correct.
So speaking about your cop friend, you can go pull the records request on the sovereign citizen videos that every single police department in the United States have been trained with, because the sovereign citizen is identified and has been since the Patriot Act as a domestic terrorist.
Yep. There's an FBI memo that has been sent out multiple times to federal courthouses, state courthouses. Yeah, if they see, they've actually said, if you see any paperwork filed where it follows this sovereign citizen process, then you need to notify us immediately. I mean,
so what if you say I'm a child of God instead?
Well, and here's the beautiful thing. They're trained to not look, they're trained. By the way, these people could cost your city and your office some money. Well, hold up, stop there. How can we cost you money if you're doing what's right?
Exactly. Yeah, and so I want to get back. I mean, don't get me wrong. I've loved this conversation, and this is why I want Brandon to join us. And I'm going to have him on again, I hope, if he will, if he's not so offended that we called him the nig Sib.
Really broke my heart, man.
We did get a little chuckle out of that. That was pretty funny. So thanks for making us laugh, Justice. She's the one that puts all of those things together. So I have to, I just have to laugh sometimes when there's a misspelling or two. So, but
yeah, I don't go back and look, and sometimes I auto dictate, so I just let it ride. So just know I'm the queen of typos.
Yeah,
and I do know how to spell. I just get lazy when I have a workload.
Yeah. So I want, again, the purpose of the Justice Revolution, the purpose of this podcast and this broadcast is I want to empower you with the tools you need to win. And what I mean by that is you can look at this and going, okay, hey, they're moving against me. They're attempting to deny me my liberty. They're attempting to deny me of my property, which is my time and my money. So if I can give you some tools, if Brandon and I can give you some tools that empower you to do that, you can see that as a win. But I'm here to tell you, if you stop there, you're not doing yourself or anybody else any favors. You need to take it the step further. You need to take it where you're saying, okay, now that you decided to think like an adult and drop the charges against me, now's my time to sue you. I'm going to bring you in federal district court. I'm going to sue you for deprivations of rights. Now, we're going to talk about that later. We've been doing that before. I want to get to right the here and the now. So Justice brought up the question. A number of you have been bringing up questions in the chat. Is like, okay, so I'm being prosecuted administratively. How do I put a stop to it? Nothing you can say in that court is going to stop it. I'm just here to tell you right now. They don't care what you have to say. They're just going to steamroll and railroad right over you. So we do everything in writing. We put it in writing. So we talked about the first step you're going to take is you're going to file a motion to dismiss, and you're going to pinpoint all of the problems in their entire case. You could stop alone on the whole lack of subject matter jurisdiction. You could stop right there if you wanted to. But I kind of like, for me, if I'm going to do something, I'm going to go full bore on it, right, Erica? And I'm just going to shove it up their rear ends. So
you want to show them just how much trouble they can get in.
Exactly. So I just want to show this to you, Brandon, because this is what I came up with. I posted this in the Affidavits group. I want to get this out to others. So if you want to share this with your folks in the Big Sib Law and in Alphonse's group, please go ahead and forward it along. But what I came up with is this, okay? So these courts oftentimes don't operate according to the rules of procedure or the rules of criminal procedure. They're operating on their own set of rules. But we're going to go back to what the Supreme Court, the Utah Supreme Court, and the Supreme Court of the United States has said is governing law, and that is the rules of civil procedure and the rules of criminal procedure. So I throw this in their freaking face. This rule right here, Utah Rule Civil Procedure 81E, is the rule that talks about those rules govern every action if there's not a specific rule outlined under the rules of criminal procedure. So I put that in their face. Then I throw Utah Rule of Criminal Procedure 25B4, which states the court must dismiss the action when the court is without jurisdiction. Boom, there's that one. Then I talk about the reasons why. Back to Utah Rule Civil Procedure 12B1, which is lack of subject matter jurisdiction, and 12B6, failure to claim upon which relief can be granted. We're quite familiar with those motions, aren't we, Brandon?
Oh, yeah. I'll face another 5 rounds here shortly of it.
Oh, I know. So then what we need to do, you guys, this is not just something where you feel like, hey, you guys shouldn't be doing this. We need to put, not only do we need to put our arguments, but we need to be able to back up our arguments with either constitutional law, case law that's in line with our arguments, or other authorities which will support our argument. It can't just be going here, well, I'm a man, I'm one of the people, and I'm a living, breathing soul, and right. You guys can't do this, and all these things. You guys, believe me, Brandon and I, we've seen it all. I know Erica has too. We've seen it all. So I put it in their face, the Utah Supreme Court, which every court in Utah has to answer to. Doesn't matter if they're moving it as an administrative court or not, they must answer to the Supreme Court. They state that before a court is authorized to act, it requires an affidavit or other pleading of jurisdictional fact, invoking the power of the court. And
that means somebody with standing. Injury in fact.
The officer's affidavit of probable cause does not invoke the jurisdiction of this administrative court to have jurisdiction over you, one of the people. You guys need to know and understand that. And I point that out here. Number 6.
Did you say every state has a law kind of like that?
Every state has an Administrative Procedures Act. Every single one of them.
Every state and the federal government.
And the feds do too. Because here's what's disgusting, you guys. The feds move cases administratively too. And you'll know it when they charge someone and it says United States of America versus so-and-so. The only time they're invoking an Article 3 court, a constitutional court, is when it says the people of the United States versus so-and-so. That's the problem. Okay? So we talk about how here in this instant case, the reason why the court doesn't have subject matter jurisdiction is because there's no affidavit or other sworn statement from the alleged victim claiming injury as a result of the alleged actions of the defendant. The only sworn statement on file is that of Officer Thompson, who based his actions and statements on hearsay evidence from an unknown, unnamed witness. Okay? You can't prosecute one of the sovereign people and have that be a binding judgment when all you're doing is writing some crap on a piece of paper and say, well, I took information from so-and-so and I went and reviewed this video over here, and because I wear a badge on my chest and I carry a gun, then this is going to stick. That's not how it works. But we got to get out of these administrative courts, and this is how we do it. That's the first one, the lack of probable cause. This is where I use that case, Brandon, where he states in his own sworn statement, based on the facts provided by him, he did not have probable cause to effect an arrest of the defendant. Because the Idaho State Supreme Court held as much, and they talked about the warrantless arrest. And down here, this is my favorite part of this case right here, Brandon, where it says Idaho Code permits peace officers to use their arrest powers to intervene in domestic violence situations, even though they have not personally observed the commission of a crime, and to thereby diffuse potentially violent crimes. Nevertheless, the extremely powerful policy considerations which support upholding this code must yield to the requirements of the Idaho Constitution. Yep. So how do we bring this back? Okay, I'm in Utah. That was a decision in Idaho.
Full faith.
How do we bring this back, Brandon?
Full faith and credit clause.
Oh,
all Supreme Courts.
What'd you say, Brandon?
The full faith and credit clause. All Supreme Courts. Remember, you got the equal protection, equal rights. Somebody in Idaho can't have more protections than you.
Yep, that's what I hit on right here. In light of this decision and employing the Equal Protections Clause of the 14th Amendment to the United States Constitution, his arrest without personally witnessing the defendant commit the crime she's being accused of violated her rights of unlawful search and seizure secured under the 4th Amendment as applied to the states through the 14th Amendment and Article 1, Section 14 of the Utah Constitution. So when the judge gets this and reads this, he's going, oh, crap, I'm not dealing with some monkey. I'm not dealing with somebody who's just going to roll over and take a plea deal. So this.
So from this point forward, So let's look at it from, and one of the great things we can do is we could practice looking from it from the other side. The prosecution is going to go, this is a $500 fine. Is it worth it?
Well, in this case, real quick, Brandon, in this case, they're trying to get $2,000 out of her.
Yeah. And even then it's not worth it. So they know at this point that you're going to invoke the right to a jury trial. You're going to you're going to cross-examine the witnesses. They're going to have to go out and find them. So they're looking at, again, risk versus reward. This is what the prosecution, this isn't a normal monkey. This one's got a baseball bat.
Yep. So here's my favorite part of this whole motion. And I think Erica will agree with this, because when I went over this last week, her face just lit up. Right?
Yeah.
So real quick, and just Brandon, I'll share this with you. You can read it. So I talk about two things: how the number 2, the criminal information is fatally flawed. Number 3, the criminal information fails to state a charge, which it does. Number 4, justice demands the information be dismissed. I say the city, the alleged plaintiff in this matter, is attempting to move administratively according to the provisions as outlined in Utah Code. This is our Administrative Procedures Act right here. The city has failed to produce any verifiable evidence on the record to show that the alleged defendant is subject to the provisions of this statute.
I do want to speak on this point, though. All right. So now, what if, let's hypothetically say they did have an affidavit from the victim, right, on the record. Now, do they have prosecutorial powers? Yes, they do.
They do.
Why? Because individual men and women cannot push crimes or criminal statutes against anyone else. The state has to take that up, or the federal government has to take up, because they have prosecutorial duties.
Yes.
So just remember that, guys. If you did have something on the record stating that it was a criminal offense, right, and you don't, she doesn't, it's not there, but the prosecutorial, so people can't just go file criminal complaints and then run with it and go in court and challenge it. It has to be picked
that's not how it works.
That's not how it works. That's right.
Yeah, but again, like I said, how do we know the difference, Brandon? Who would be named as the plaintiff?
The people.
The people.
Yeah.
So
because the people would recognize him in his capacity.
Yep. And because the people and the peace and prosperity of the people is threatened by him or whoever is being charged with this crime, by them being allowed to be free. That's why. It threatens the peace and security of the people. I could give a rat's rear end about the peace and security of St. George City or the state of Utah.
It doesn't have the ability to have peace.
I don't freaking care. Don't freaking care. So I talk here again. The record clearly shows that the city is attempting to deny the alleged defendant her unalienable rights as enumerated and secured by the Constitution for the United States and the Utah Constitution, namely her right to know the nature and cause of the accusations against her, her right to face her accuser, and her right to a speedy trial by jury. So this is my favorite part. Tell me what you think of this here, Brandon. The city is attempting to bypass the alleged defendant's rights in an attempt to extort monies as fines within a simulated legal process. The Utah Supreme Court has held that this process is unconstitutional when applied to a private citizen. Accordingly, abbreviated administrative type proceedings are constitutionally insufficient in the context of criminal investigations by the state's prosecutors.
Read that again.
Accordingly, abbreviated administrative type proceedings are constitutionally insufficient in the context of criminal investigations by the state's prosecutors. Dilution of citizens' rights by a strained analogy to administrative subpoenas and procedures simply ignores the fundamental safeguards that the law has always recognized in criminal procedure for the protection of individual liberties. And
so here we go, because you're a common law state, right?
Yep.
So it would follow the common law procedure.
Yep. So that's where we are with this. So let me, I know, gosh, here we are 1 hour and 11 minutes into this. And we finally get to the point I was trying to make. But I feel like this has been really good. This has been really good.
We hit a lot of big picture things that I think you need to have that big picture understanding before you can understand all the little details within. So it's good.
I gotta put this up on the screen and read this. Heather says, this monkey has got a baseball bat.
Good for her. Good for you.
Obviously, that's figuratively speaking, not literally speaking. So
that's right. That's right.
So here's what I told her. So I gave her that motion and I said, here, send this to your lawyer, your defense attorney, and have him file it in the court. So she does, and then he replies back, I'm not going to be filing this. He's like, I won't do it. And I was like, okay, why don't you reply back to him and say, you will do this. Otherwise, I will bar grieve you and your named partners for every week until you do. He replies back and he's like, and I'm paraphrasing here, something to the effect of, the law does not compel me to do this, nor does my ethics. Something along those lines.
It does. You took the case, buddy.
You did take the case. So, so then he's like, you're welcome to fire me or represent yourself or find someone else. And then so I told her, I was like, you're not going to fire him. If he wants to withdraw from this case, he's going to have to convince the judge who appointed him to you why.
Yeah, he's got to put in a motion to withdraw.
Yeah, he does.
If he refuses to be her counsel, he's got to put in a motion to withdraw from counsel. Yeah,
because you can appeal cases for ineffective assistance of counsel.
That's right.
So he needs to. I mean, it's really sad, you guys, when a truck driver like Brandon and a lowly software salesman like me know the law better than somebody who allegedly went to law school. It's really sad. But,
well, Scalia, that's one of the greatest quotes in this book. No way I'm going to find it, but he says, how does he do it? Scalia says, he says, incompetent lawyers become horrible judges. And he said, unfortunately, our law schools have failed for the last 60 years. Remember, I told you there's this magical cutoff. There's this just the world went retarded. It's like, by the way, we're just going to shut down our learning center. And you can bring in I love these conversations because you can get philosophical. For 60 years, we got 60 years of hard factual evidence that everything the government put their hands in has failed.
Yeah.
Affirmative action, welfare state, education, whatever they put their hands on, it failed.
Yeah. Yeah.
That's why we had a limited government.
That's why. So I was chatting back and forth with Heather yesterday, and when she told me that her attorney was not going to file this, I'm like, okay, that's fine. You can go ahead and file it yourself, and he better be prepared to argue for it. But that's whatever. And I said, you're going to go ahead and bar grieve him now anyway for not doing what you want him to do. So I sent her the link to the Utah Rules of Professional Conduct.
Yeah.
And let me show you what she found, and this is perfect. Scope of representation and allocation of authority between client and lawyer. It says a lawyer shall abide by a client's decisions concerning the objectives of representation and, as required, shall consult with the client as to the means by which they are to be pursued. A lawyer may take such action on behalf of the client as it is impliedly authorized to carry out the representation. I call them liars. A lawyer shall abide by a client's decision whether to settle a matter. In a criminal case, the lawyer shall abide by the client's decision after consultation with the lawyer as to a plea to be entered, whether to waive jury trial, and whether the client will testify. So she filed a bar grievance and cited that rule. I think it applies to you.
It's hilarious when you read these rules and you recognize that the rules were eventually made for our benefit, right?
Yeah, they were.
What possible excuse could the lawyer have for not wanting to submit that? It's brilliant, and it speaks to defend her.
He's not on her side.
Go ahead. Because he doesn't want to walk in there and shake his egg basket. That's why.
Exactly.
Because he's going to have to walk in there to that judge and actually fight for the client zealously, right? And instead, he wants to walk in there and get a plea deal, and then they go back in the back room back there, have drinks, or go to golf. because it's a big old club, like George Carlin said it, and you ain't in it.
It's a club, and you're absolutely right. Again, you've got two opposing parties. They're both represented by bar association members. Their allegiance, their duty is to the bar association, not to you as a client.
So his ethics really do stop him from doing it.
Yep.
Or his oath.
Right.
Yep.
He's got poor ethic. Yeah. That's like
and that's why I'm saying, and because she's come back and forth. She's like, well, should I just get another attorney? She's like, I can't afford an attorney, so I need one appointed. I was like, well, here's the thing. I've seen people who have taken these cases on their own, representing themselves, going through pro se, and it's not pretty. I mean, the court really, they really will railroad you no matter what you do, and they're going to get a conviction one way or another. And when they do, your only recourse at that point is to try and go fight it in federal court or try and get that judgment vacated, like I talked about before. So I said, your best bet is to keep the stupid idiot as your counsel, bar grieve his rear end, will bar grieve the prosecutor, and for good measure will bar grieve the judge until they all come to a decision like, this woman is too hot of a potato for us to deal with. Get her out of my courtroom.
Mm-hmm.
I know the situation.
Even if you invoke their anger, when people are angry, they make mistakes.
They do.
Listen. I'll give you
a good example of that, Brandon. So you and I know this individual. I won't refer to her by her name or by her Telegram screen name. She's in a Western state, and she was in court the other day for a trumped-up administrative charge, and her sole purpose was there to challenge the jurisdiction of the court. And she's like, no, we're here we're only here appearing specially. We're not appearing generally. We're here to challenge this court. The judge said, unless you step in and accept appear generally, you're going to be held in failure to appear, not contempt, failure to appear.
And does he have legal grounds for that?
No, he does not. But the judge, actually, it was a woman judge. And what she said was, they were in this court. They were there for 8 hours. There were all these people there. Yeah. When they got up in their turn, they said, well, we're only here appearing specially. We're here to challenge the jurisdiction of the court. This woman cleared the courtroom and moved the courtroom to another one where it was just her, her boyfriend, the judge, and the bailiff.
Wow.
So, and
what does that say?
Exactly. So when they would not do what the judge asked them to do again, the judge would not let them come into the court. And she issued a $25,000 warrant arrest for their arrest. Now, tell me, who's the real criminals here?
Oh, well, it's the RICO.
Well, we all know.
Yeah.
Hence the Justice Revolution.
Organized crime. That's exactly right.
Yeah. They give you these fantasies about the mafia and everything else, but to get your mind pointed somewhere else. Mm-hmm. But who's really coming to extort you out of your money from your home?
The thugs and the mobsters are going by different names, like judges and lawyers.
Mm-hmm.
Yeah. Well, so let me just give you a quick update here on our good friend Heather. Thanks again for allowing me to use you as our guinea pig, no pun intended. So she, again, I told you she had the precipitating charge we just went over. She now has felony charges in a district court for violating quote unquote a protective order. She was never issued a protective order,
which there's no evidence of, right?
Yeah. Well, she did find there's a document that the people at the jail made her sign, but there's no judge's signature on it anywhere. According to the law, the Utah law that governs protective orders, there's two types of protective orders that can be issued. An ex parte protective order, which is one where danger is imminent. We need to do something quick. I'm going to do this now, but there must be a hearing on this to determine whether there's going to be a permanent protective order in place or it's going to be terminated. That's what that is. Both documents are required to be signed by a judge. Also, the law requires that document, the protective order, be properly served according to the Utah rules of civil procedure for the process of for serving someone. So there must be verification that the document was served, and then someone must sign an affidavit that they did it.
Which means they need to use a serving processing company.
or one of the sheriff's deputies can do it.
Okay.
However, whoever serves the document is required to swear under oath that they did so through an affidavit.
Okay.
And that affidavit gets filed into the court record. It's nowhere to be found. So you guys can see how this is really just, I mean, they always talk about organized crime. They always talk about the mafia, stuff like that. Well, where do you think those guys learned it from?
Yeah.
They learned it from our government. That's where. So
this state court has no jurisdiction in a nutshell, and you are creating a grounds for dismissal based on that.
Yeah. Remember what we go back to our discussion about jurisdiction. In order for the court to have subject matter jurisdiction, they must have two things. Do you remember what those two things are, Erica? Because
I thought there were four things, because the plaintiff and the defendant.
Yeah, that's the jurisdictional table, right? Right. There's the four legs.
Jurisdiction.
Yep, in personam jurisdiction.
And subject matter jurisdiction.
Yeah, but what I'm saying, subject matter jurisdiction is actually comprised of two things. Do you remember what those two things are?
Yes. Hang on.
You consult your notes.
Give me a hint. Give me a hint.
Okay, so I'll give you a quick hint. The first one.
Standing was one of them. Like
an injury in fact.
Injury in fact.
Yep. So there's two things. In order to invoke the jurisdiction of the court, because remember, courts do not inherently have power to do anything until we, the people, bring them a case or controversy to invoke the power of the court. So there's two things that court needs: the common law authority, the statutory authority, in order to invoke the jurisdiction. That's the first thing. The second thing is you must be able to prove injury in fact, and you do that with an affidavit saying I was harmed, or this individual presents an imminent danger to me, or this policy presents an imminent danger to me, and I can prove it.
That's right.
That's how that's done. So in these cases that we just reviewed for Heather's case, there is nothing in the record that invokes the second part of that jurisdictional piece. And you can make the argument that the first part doesn't apply either, because you go back to the definitions of the term person, and you're like, well, hey, that's this is clearly a corporation. I'm not a corporation. I'm not a creature of the state.
Well, it simply goes back to a circumnavigation of your civil procedure and criminal procedure to whip up these courts. And listen, is there a lot of people going through the courts? Was the original administrative procedure maybe thought of something to help the caseloads? Probably so.
Probably.
But just like all things that are originally intended for good, what happens with the general nature of mankind?
They realize they can make money off the ones who aren't paying attention, and then they exploit it.
That's right. That's right. Oh, we got a money racket right here.
Right? That's how income tax is working. All right.
Yep. Dawn, territorial jurisdiction is not a prerequisite. All that territorial jurisdiction involves with is, did the alleged matter, either the civil or criminal matter, happen within the territorial area that this court can handle? That's all that is. So again, I taught, and Brandon's the same way. I want to teach you guys that golden bullet, that silver knife. We want to give you guys that tool that can be used to win. Now, this is a great question here, Carrie. Questions of jurisdiction, can they be raised at any stage of the pleadings? Subject matter jurisdiction can be raised at any time, even after a quote unquote conviction.
That's right.
Now, personal jurisdiction can be waived. So going back to my story where that young woman in a Western state from here was trying to appear specially and not generally, that judge was trying to get her to waive her personal jurisdiction, and she was standing her ground. Good for her. Okay.
Very good for her.
Very good for her. So,
and again, a common tactic is to extort you, right?
Yeah.
And how long has this been going on? Look, we'll blackmail you and we'll send our Gestapo after you.
Yep. Yeah. You guys, I mean, this is what's so infuriating is, and this is what's even happening now. So I'm going to pull up real quick, and then we're going to end this up here. I want to show you, where is it? I want to show you this motion to dismiss that a friend of mine wrote where he got out of a traffic ticket. And it's interesting too, is that in this motion, he does the same thing I talk about here, where he says, where he attacks the statute and the wording of the statute. So he was given a citation for his car not being registered. He talks about the statement of facts here. Then he talks about the discussion, and he looked in the statute here, and it says under the definitions, there's that word again, right, Brandon? Mm-hmm. Under definitions, it says vehicles exempt from registration. A vehicle that is driven or moved upon a highway only for the purpose of crossing the highway from one property to another.
There you go.
Isn't that if I take my personal truck from my house and move it from my property to the property of Walmart?
Yeah.
I mean, it's brilliant when you look at this.
Well,
and then he goes in here
it has to be there too. Up until 4 years ago, Louisiana didn't require anybody to have insurance. Why?
Yeah.
Because it's an actual violation to force you into a private contract.
Yes, it is.
And it's always going to be.
Yeah. There's actually a plethora of Supreme Court cases that validate that you don't have to have license.
Oh, yeah. And we can have a whole discussion on this, but I want to get to this part here, because when you look at the citation that he was issued from the Utah Highway Patrol, it's really blurred out. You can't see it, but it says right here where my cursor is section 77-7-206, and it says failure to appear is a misdemeanor. Basically, it's saying that if you don't show up to court, you're going to be charged with a misdemeanor. Well, guess what? This law was repealed in 2018, but it's still on the tickets they're printing.
Wow.
So he points that out. Repealed by SB 58. This is Senate Bill 58 in 2018. Fraud. Never signed this. So he won his case, by the way. His case was dismissed.
Great.
And again, he followed the process where he filed the paperwork, gave them a chance to answer. The prosecutor was lazy and chose not to because, again, it's a traffic ticket. It probably had a $200 fine. And so he moved the court to issue a ruling. And where the other side didn't answer timely, the court ruled in his favor. So there we go.
Good on that judge. There are some good judges. Even in the administrative courts, there's good judges.
They are few and far between, but they are there.
They are there.
Yeah, we should do an episode on success cases. Just show them all and talk about them for people.
We will. You know, we'll be doing one here shortly, or I don't know how long it's going to take once they get Heather's case resolved and taken care of. So I've told her what to do next, and she's doing that. And, you know, God bless her that she's, you know, Brandon knows this. How many people reach out to you for help, Brandon? I mean, gosh. I mean, every single day I get 2, 3, 4, 5 messages in Telegram. Please, please, please help me. Please help me. And I would love to, you guys. I really would love to. I am not physically capable, and my brain can't handle it. My wife is like, oh, great, you're doing something else for someone else now. She's like, because she knows I'm a big pushover. Right? That's just how I am. So, but I can't stand to see injustice carried on someone, and I want to be able to empower my brothers and sisters. So that's why I do this, and that's why we have this show. But to the point I'm trying to make is, do yourself a favor. Learn how to do this stuff. If you need help, we're here to help. Post your stuff in the Telegram chat. Post your stuff in Brandon's chat, the Big Sib Law. There's some brilliant people in there sharing stuff back and forth. If you need, you know, guidance, as you go, hey, this is what I did. Now what do I do? We're here to help you with that. The only thing we can't do is take on your case and write your documentation for you. I can only do that for a limited number of people. And I pretty much have
I've reached my limit. I've reached my limit.
Brandon is, I mean, bless his heart. He is suing a chief district judge of a federal court.
Awesome.
It is awesome.
You should bring that online. We talk about it.
This
is how people learn. If they see the cases and we go through them like we did today, and they see, so that would be great.
Yeah.
Yep. So one last thing I want to show real quick. Thank you, Tom. Appreciate you. He says, I like the shirt. Yes. Thank you. Appreciate that. So,
hey, Tom, how you doing, brother?
Yep. Yep. Tom's a good dude. So, everyone, we, like I said, I've told you before, we never do. I like to try and keep these to an hour. Here we are, an hour and a half, but it's okay. It's been really good. Been good information. I just want to leave you guys all with just this, is you can do this. Okay. We're giving you the tools. Everything that Brandon and I do is posted in our Telegram groups. Brandon posts everything. His lawsuits he writes, any motions they write, any replies to motions they write. They're in his group. Everything I do is in my group. We try to cross-share them across groups so you guys can get them. Again, take our stuff, plagiarize it. It's not only allowed, it's encouraged when it comes to writing stuff. So if you find something that I've written or that Brandon has written or that Alphonse or anybody has written, any of them.
Brett's a very, very efficient writer.
Yep. Randy is another great one. Brett's another great one. If you find any of the stuff that they write and it works for you, copy it and paste it. There's nothing wrong with it. Go ahead and do it. So,
someone's asking about the Telegram link. Dawn, are you asking for Brandon's Telegram link? Whose Telegram link are you asking for?
Yeah, the Telegram link.
Post that, and we'll do our best to get it for you.
Yeah. Do you have here? Let me see if I can find it real quick.
Ours is just Affidavits 101. What is yours, Brandon?
I'm posting it in the chat right now. I keep mine private.
Okay.
He's
by invitation only.
Well, I do that here. I'll post it to you, and you can post it in the chat. The reason we do that is for the bots.
Yeah, they're really bad.
We keep all the bots out of our group so far. So,
Yep.
Yeah. And hey, look, guys, you can find the Big Sib chat. You can find that. It's open. From there, you can find your way into the Big Sib law group.
There you go. Okay, well, with that, everybody, we're going to wrap this thing up and let you all enjoy your weekend. Thank you so much for spending an hour and a half with us here on the Justice Revolution. Any final words, Erica, before we take off?
Yeah, something that my youngest son and I were studying just today, and that he had the light bulb go off on for him, is that your rights are yours. And you can't expect someone else to assert your rights for you. You have to do it yourself. So this, if you're feeling like you can't do this and like you need someone like one of these guys or one of us to help you with it, you learn by doing it, and then you learn, it builds you up even more as you gain the knowledge to be able to stand in it and to keep standing in it. So don't try to have someone overhelp you. It's part of the process, is learning it and digging into it.
So true.
Yeah, Tom had said, let me find it this earlier.
While she's finding that, Erica, your son, boy, I love that kid. How old is he again?
Wait till you'll see what he's working on. His assignment this next week, because his microphones are coming in. He's doing what do you call it when you go out and you ask people questions? Like not a survey.
Audit. Yeah, auditing.
Well, just asking one basic question. Why was the Constitution written? Just to get a general, because we were talking about de Tocqueville last week, actually, in his observation that every single person he ran into knew everything. And we're both so surprised at, like, one of the videos we were watching the other day, they offered $100 to anyone who was passing by in the Walmart, to anyone who could name 5 books of the New Testament, no one knew it. Are you kidding? But it just goes to show like where we are and why we're all slaves to everything, because we lack the knowledge. And so, he's doing some pretty cool stuff with the knowledge that he's learning.
That's awesome.
That's exciting.
Did you find it, Justice?
No, I didn't. But basically, reading. We need to immerse ourselves more in reading, which is true. And we all have different levels. Like, it's no secret I get overwhelmed easy with legalese and stuff like that. I mean, and some people they get it like that. So God gives us all our own, aptitude and capabilities, but don't let it deter you. Don't let it stop you.
The easiest thing to do is have hard copies of books. And I do this. And the reason for that is, do you think I can remember every single one of the 47 canonical rules of construction, 375 pages? No, I cannot. It's impossible. What I can do is associate the words to memory and remember the most important rules, right? And know that, hold up, let me go get my book. Let me clarify this, right? And that's what you do. It's very simple. And then as you read, you'll learn how to write. And he who can think effectively can write effectively, right? That's it. It really is. Language is this great art that must be learned. It is an art.
You know, I never knew.
We don't know what we don't know. So if you don't even know what question to ask because you don't know enough to even ask the question.
Yeah.
That's what the exposure of your groups does, is that it presents ideas to you that's like, oh my gosh, I didn't even know that was a thing. Okay. So
you know, and to Brandon's point, you know, I didn't know I could write as well as I can. I still don't think I write very well. But when I put my thoughts on paper, especially when it comes to legal arguments, and I go back and I read it, and I'm like, wow, I didn't know I could write that good.
So, you know, that's actually a homeschool. We follow the homeschool by Art Robinson called the Robinson curriculum. And it's reading, writing, and math. That's it. There's no grammar. There's no spelling. And the book list is 100-year-old books. And he said, within reading the grammar and the sentence structure and everything in those books, your kids will learn to read and write effectively. Well, I have to tell you, my daughter's now in 10th grade. 2nd grade was her first year. She spits things out that I'm shocked. And it's absolutely the 100% the truth, Brandon, what you're saying.
Yeah. Well, hey guys, this has been I really have enjoyed this time. Thanks, Brandon, buddy. Thanks for jumping on. And hope Grandma's doing okay. Hope she's better.
She's in rehabilitation and will be for 4 weeks. But good thing is she's going to make it.
Good. That's good to hear.
Oh, that's blessings.
Well, everybody, thank you so much. Enjoy your weekend. God bless you all. And until our next episode, take care. Thanks, everybody.
Bye.
See
now.
ya. Whoops.
James.
Got a little